Welcome back to the deep dive. We take the source material you send us, articles, news reports, all of it, and we boil it down to what you really need to know.
And today we are strapping into the passenger seat.
Yeah.
We're looking at the world of personal transportation liability, specifically in Tampa, Florida, where things are changing and fast.
They really are. It's this fascinating collision of two worlds, isn't it? On one hand, you've got the reality of Uber and Lyft human drivers, but with this incredibly thorny legal structure.
And on the other, you have the imminent arrival of Waymo. We're talking fully driverless cars just beginning to test on those same streets.
So our mission here is to really give you a map for all this. First, we're going to unpack those insurance gray zones with Uber and Lyft, where a simple tap on the app can change everything.
And then we'll pivot to the whole new set of challenges that come with autonomous cars. Legal, technical, and just psychological challenges.
It all really comes down to this core conflict our sources point to: convenience versus accountability.
Exactly. You tap a button for a ride, you expect it to be simple. But if there's a crash, that convenience just evaporates. And you quickly learn that Uber and Lyft accidents follow completely different insurance rules in Florida.
Knowing those rules is everything.
It's the difference between getting the help you need to recover and being, frankly, financially buried.
Okay, so let's unpack that. Let's start with the here and now. What happens when that simple, human-driven rideshare trip turns into chaos?
Well, the initial experience is it's overwhelming. You're trying to deal with a medical recovery, and at the same time, you're thrown into this insurance maze.
You're trying to deal with doctors, but you're also getting bills. And you're trying to get answers from this huge tech company that's suddenly gone completely silent.
Right, and a driver who might be impossible to reach. You feel like you're fighting a ghost.
And that's the part that feels so unfair. The person who's hurt is suddenly tasked with becoming an investigator.
Yes, you're expected to chase down app logs, insurance policies, all this data, when you should just be focused on getting better.
So what's the legal trigger? What's the one thing that makes these cases so different from a normal car wreck?
It all comes down to one thing: the driver's app status at the exact moment of the crash.
Yep, app status.
That's the key that unlocks the company's big corporate insurance policy. If you can't prove the right status, our sources say the compensation you need could vanish.
Vanish? How does it just vanish? What's the mechanism there?
It's because of the driver's personal car insurance. Almost every single personal policy has a specific exclusion for commercial use.
Meaning driving for hire.
Exactly. So if Uber's lawyers can argue the driver wasn't officially on a trip for them, their big policy doesn't trigger. Then you go to the driver's personal insurance and they just point to that exclusion and say, sorry, we don't cover that.
And suddenly you're left with no one to file a claim against.
You're left fighting just to get the app data to prove what was really happening. So proving that app status isn't just a technicality, it is the entire foundation of the claim.
Okay, so let's break this down for our listener. Let's walk through these different phases of coverage you mentioned.
Let's do it. Scenario 1 is the most straightforward. You are a passenger in the car.
You hailed the ride, you're in the back seat, and a crash happens.
In that case, the moment the driver accepted your ride request, the rideshare company's $1 million commercial liability policy should apply. The goal is to establish that clear timeline.
That sounds pretty clean. Where do things start to get murky?
It gets much trickier in scenario 2. This is when you're hit by a rideshare driver, maybe you're walking, or in your own car.
Okay.
Here, everything depends on what the driver was doing in those in-between moments. Was the app on? Were they waiting for a ride request? Were they on their way to pick someone up?
That's the insurance gray zone.
That's it, exactly. Because the level of coverage is different for each of those stages, and it requires a real investigation to pin down what was happening.
I can just picture it. A driver causes a serious accident, and the first thing they do is panic and just turn the app off to cover their tracks.
It happens, and that's a perfect example of the challenge. The driver has the power to destroy the evidence on their end in an instant.
So how do you prove it?
You have to move fast. You get a lawyer to put the company on notice, demanding they preserve that data. And if they don't cooperate, you file a lawsuit to subpoena their records, the app logs, the GPS data. Without that legal pressure, they have no reason to hand over the very evidence that makes them liable.
So speed is absolutely critical. What about that third phase you mentioned, where the app was off, but the driver was still kind of working?
This is the toughest spot. The app is off. Maybe they're switching between platforms or just taking a break. This is where the companies try to push all liability back onto the driver's personal policy.
Which we already know will deny the claim.
Right. It creates that dead end. The investigation then has to prove that even though the app was toggled off, the driver was still doing something related to their commercial work. It's a tough argument to make.
So once you establish coverage, let's talk about compensation. This isn't just about getting your car fixed. What is an injured person actually entitled to in Florida?
Well, it's about making a person whole, which covers a lot. Obviously, there's the emergency medical care, but also ongoing treatment, physical therapy, mental health support, things like that.
And it covers lost income too.
Yes, the money you lose from being out of work right after the accident. But it goes deeper.
What do you mean?
Our sources point to something called diminished earning capacity. That's a lot harder to calculate.
It sounds like it. How does that work?
Lost wages are simple math. Diminished earning capacity is about the future. It's the difference between what you would have earned over your career if this never happened and what you're projected to earn now with your injuries.
Wow. That requires experts, I imagine, economists and so on.
Oh, absolutely. Forensic economists, vocational experts. It's a complex but critical part of a serious injury claim. And then beyond all the financial stuff, there's the human cost.
Pain and suffering, the trauma.
Exactly. And that's what those first quick settlement offers from the insurance companies completely ignore.
Those lowball offers, why are they always so low? Is that just standard practice?
It is standard, but it's amplified here. These companies have so much data, they know what the average person will accept out of desperation. They make a low offer, hoping you'll take it and go away before you realize the true long-term costs.
Or before you realize you're running out of time.
Precisely. They know that in Florida, the statute of limitations is generally just 2 years. Every day that passes is leverage for them.
Let's talk about the absolute worst case scenario, a hit and run. A rideshare driver hits you and just flees. You might feel totally helpless.
You might feel that way, but you are not without options. This is where a specific part of your own car insurance becomes a literal lifeline. It's called uninsured motorist coverage. Okay, break that down for us. What is coverage? It's insurance you buy on your own policy. It's there to protect you if you're hit by someone with no insurance, or, and this is key here, if you're the victim of a hit and run and the driver is never found.
So you can make a claim against your own insurance company even if you don't know who hit you.
Yes, for your medical bills, lost wages, pain and suffering. It's essential protection, especially in a state like Florida where things can get this complicated.
This human-driven world is already so complex. Liability hanging on a single tap on a phone screen. But now we have to shift gears completely.
We do. We're moving from human error to algorithmic accountability.
Because Waymo is now officially testing its driverless cars in Tampa.
That's right. It's a fascinating shift. Waymo is out there right now, mapping the roads, getting ready for a passenger rollout they're hoping for next year. They've already done this in Orlando and Miami.
What do these cars actually look like on the street?
They're pretty distinctive. They're electric white Jaguars, covered in sensors. You'll see the spinning LiDAR on top, cameras all around. It's all designed to build a 360-degree digital picture of the world around it.
And they're justifying this fast rollout by saying they've logged over 100 million miles of autonomous driving nationwide. That's a staggering number.
It is. That much data allows them to adapt their system incredibly quickly. They aren't starting from scratch. They're showing up with a very educated algorithm.
But does an educated algorithm equal immediate public trust? That seems like a whole new problem.
That's the next mountain to climb. And on the regulatory side, it's interesting who has the power here.
Right, so Waymo has to follow Tampa's traffic laws, but who actually regulates them? The city.
No, and this is crucial. The state of Florida regulates everything related to rideshare operations, and that includes these robotaxis.
So the rules will be consistent across the state, from Tampa to St. Pete.
The state sets the rules for testing, for licensing, and ultimately for liability, which helps. But you're right, the human element is the big question mark.
We have a quote from a professor at the University of South Florida, Tencel Uslin, who calls this a significant milestone.
It is. And he really nails the core psychological problem. He says we're being asked to transfer trust from a human they can see to a technical system which they cannot see.
That's it, isn't it? We can understand human error. We see a driver make a mistake. It's frustrating, but it's relatable.
But an algorithm failing feels different. It feels cold, calculated. We see it as a failure of the entire technology, not just one bad decision. Overcoming that requires near-perfect performance.
And their performance isn't perfect, it's under a microscope. There's that open investigation by the U.S. Safety Agency.
Right, concerning Waymo vehicles in Texas that allegedly drove past stopped school buses.
That gets right to the heart of it. Can the code understand all the little nuances of traffic safety laws?
That's the question. It's not about the engine failing. It's about perception. Did the system see the stop arm? Did it correctly predict what a child might do? Waymo says they fixed it, but it shows that even 100 million miles can't predict every single variable.
So legally, if a Waymo car causes a crash in Tampa, the whole game changes. We're not talking about negligence anymore.
No, we are now firmly in the world of product liability law.
Can you explain the difference?
With a human driver, you ask, were they negligent? Did they break a rule? With an AV, you ask, was the product defective? Was the software flawed? The liability shifts entirely to the manufacturer, to Waymo.
Which, in a way, is simpler for the injured person. You know exactly who to go after.
It simplifies the target, absolutely. You're dealing directly with the corporation, not trying to figure out an independent driver's insurance status.
So let's bring this all home for the listener in Tampa. We have the complicated present and this very different automated future.
The takeaway for today's rideshare world is all about forensics. The app phase is everything. You have to secure that evidence to trigger the corporate coverage.
And for the future,
For the driverless future, it's about regulation and trust. We need strong state-level rules for when these systems fail, and the companies need to figure out how to bridge that massive psychological gap with the public.
it's fascinating. The whole question of liability it morphs. In the human system, the question is factual. Who was driving and was the app on? It's tangible.
Right.
But when you remove the human completely and the liability rests entirely on the corporation and its algorithm, does that actually simplify the question of accountability? Or does it just make it more complicated in a different way?
It definitely simplifies the target, which is the company, but I think it complicates the proof. The fight is no longer about human testimony and crash scene evidence. It's a fight over proprietary source code and algorithmic decision-making logs. The whole question of liability moves from the phone screen right into the code itself. And that's going to require a level of legal transparency that, frankly, we're only just beginning to figure out how to demand.